Welcome to Lecture 3 in this series on critical reflections on the EU's data protection regime. The previous lecture examined invisible power in administrative data processing. Professor Bart Schermer now turns from the person affected by a system to the organization designing one. His chapter asks whether Article 35's data protection impact assessment requirement actually reduces the risks to rights and freedoms in practice. Schermer combines doctrinal analysis with a survey of 61 Dutch privacy professionals and his own professional experience. He treats those empirical findings cautiously. The sample is small and national. Their value lies in showing how practitioners experience the gaps between a high-level legal duty and the everyday work of assessment. The GDPR takes a risk-based approach. Where processing is likely to create a high risk to the rights and freedoms of natural persons, the controller must conduct a data protection impact assessment before processing begins. This duty converts an established governance technique into a legal obligation. Before the GDPR, organizations could use privacy impact assessment as a voluntary control. Article 35 now requires the control itself, and failure to conduct an adequate DPIA can amount to an infringement even where the underlying processing might otherwise prove lawful. The chapter therefore asks more than whether controllers complete the document. It asks whether the exercise changes the design, scope, or safeguards of the processing activity. A DPIA performs two functions. First, it identifies possible adverse consequences, assesses their likelihood and severity, and develops measures that remove or reduce those risks. Secondly, it demonstrates accountability. Article 35(7) requires a systematic description of the processing and its purposes, an assessment of necessity and proportionality, an assessment of risks to rights and freedoms, and the safeguards and security measures envisaged. The same instrument therefore serves designers, managers, lawyers, and regulators. That dual role creates values, but it also creates tension. A process designed to improve a system can become dominated by the need to produce an audible record. Once documentation becomes the organizational objective, the DPIA risks recording decisions rather than shaping them. Schermer's central criticism concerns procedural vagueness. Article 35 specifies minimum content, but it does not prescribe a single method for conducting the assessment. The GDPR's meta-regulatory character explains that choice. A rigid statutory method would fit some organizations and fail others. Flexibility allows controllers to integrate assessment into existing risk and governance processes. Yet the same flexibility produces divergent templates, inconsistent scope, and uncertain quality. Procedural vagueness is therefore both feature and defect. It preserves context-sensitive judgment, but it also leaves organizations to decide who participates, when the exercise starts, what counts as sufficient evidence, and how mitigation feeds back into technical design. The EDPB offers a useful cycle. Describe the proposed processing, assess necessity and proportionality, examine the risks, identify measures, document the outcome, and monitor the system. Schermer does not reject that map. He questions the operating detail beneath it. The guidance says little about how organizations should involve engineers, designers, business owners, or the affected groups. It also places necessity and proportionality before the detailed risk assessment, even though realistic alternatives and mitigating design choices often emerge through the assessment itself. The process must therefore operate iteratively. A DPIA should repeatedly revisit purposes, alternatives, and safeguards rather than move through a checklist once and close the file. Article 35 refers to rights and freedoms, not only to privacy in a narrow sense. Schermer therefore argues that a DPIA should examine every plausible rights impact attributable to personal data processing, including discrimination and other civil, political, social, cultural, or economic consequences. Practice remains narrower. In the survey, 69% of respondents considered civil and political rights, while 39% considered social, cultural, and economic rights. Templates can determine the field of vision. When a category of harm does not appear in the form, teams may treat it as outside the exercise. Scope also becomes harder as DPIAs overlap with transfer assessments, AI fundamental rights assessments, children's rights assessments, and DSA systemic risk duties. The GDPR says that the controller must complete a DPIA before processing, but it does not specify the stage of product development at which work should begin. That omission counts for something. An early assessment can change architecture, data flows, retention periods, defaults, and access controls. A late assessment usually validates choices made elsewhere. The survey reflects mixed practice. 28% started near the beginning, 30% conducted the DPIA throughout development, and 18% began near the end. Organizational motivation also matters. 41% identified compliance as the principal driver, while only 18% identified product or service improvement. Article 35 works best when it operationalizes Article 25's data protection by design and default. Responsibility remains with the controller. The DPO advises on the DPIA and monitors its performance. When the controller rejects that advice, the EDPB expects written reasons. Schermer accepts the importance of the DPO's independent position, but warns against treating every disagreement as evidence of intentional infringement. Proportionality can produce legitimate differences of judgment. Article 36 creates a second tension. The most coherent reading triggers prior consultation when residual risk remains high after the controller has applied the measures it can reasonably implement. Consultation is not ordinary prior authorization, and the supervisory authority does not replace the controller's assessment of legal basis or necessity. Even so, 23% of the survey respondents had sought prior consultation during their careers, so Article 36 is not simply a dead letter. The chapter reaches a qualified positive conclusion. 79% of respondents agreed, or strongly agreed, that DPIAs had raised the level of privacy and data protection in their organizations. Business sentiment proved less positive because cost, complexity, time, and uncertain benefit remain visible. Schermer therefore resists a single mandatory methodology. He calls instead, for example, DPIAs and shared best practice, better integration with privacy by design, practical guidance on interdisciplinary participation, and a combined approach to overlapping assessment duties. Article 36 should state more clearly that high residual risk triggers consultation. The objective is not more documentation. It is a practice infrastructure that helps organizations identify alternatives and improve systems before risk becomes fixed. The core takeaway from Professor Schermer's chapter, for me, is that Article 35 has been a net positive, but the legal duty does not guarantee an effective assessment. A DPIA protects rights when it starts early, includes the people who understand the system and the people who may bear its risks, and changes design rather than merely documenting it. Do not forget to check out the next video in this series, where we turn to consent as a legal basis, a claim about autonomy, and one of the most contested mechanisms in European data protection law.